Thank you, one and all, for joining us on this beautiful sunny morning as we discuss the Renters Reform Bill, what's next for landlords. Perhaps if I start with a brief introduction to our speakers today. All four of us are property practitioners with expertise in landlord and tenant matters, but we all practice more widely or broadly across property and estates. Rachel Bale has a specific interest in collateral disputes and kind of real property issues. Victoria has a particular emphasis on environmental disputes, so public and private nuisance, environmental issues and nuisance issues in a public and private context. And Aaron's focus is on collateral claims and interest in land, so easements and the like. So if I can deal firstly with today's agenda, this is going to be an interactive webinar where we'll be discussing the proposed legal changes that are set out in the bill going through Parliament, and also trying to provide practical guidance for landlords who are letting properties in the private rental sector. So today's agenda, we're going to be covering off 5 core topics. The first is the scrapping of Section 21, so no-fault evictions. Secondly, we'll be dealing with the end of fixed-term tenancies and also the implications for that on rent review clauses. Thirdly, we'll be covering the proposed strengthened mandatory grounds, so the grounds on which you can then obtain possession. Fourthly, for those who are animal people or are not animal people, I suppose, the tenant's rights to request a pet in their new home. And fifth and finally, we'll be talking about the kind of ADR scheme that's incorporated into the bill, and that's the introduction of a new Ombudsman and a new portal through which to settle disputes. So these are the 5 topics that we are generally going to be covering. But before we start with that, I suppose the first issue is dealing with when will this bill be implemented? And we had 2 questions on this topic. The first is, do we have any indication when Section 21 will actually be scrapped? As clients are already asking if we know. So the bill is currently in its infancy. It's having its second reading in the House of Commons at the moment. So we are a long way away from its being enacted. So there is still the possibility for amendments and also the possibility of the bill being scrapped altogether. So if Rishi takes up Keir Starmer's suggestion in question time yesterday, or PMQs yesterday, of holding a snap election, who knows, maybe Labour will scrap it. I think it's highly unlikely given Labour are hardly going to be on the side of landlords. But yes, this talk may well be wholly irrelevant if the bill is scrapped, but I think that is probably highly unlikely. We can't give exact timings of when we anticipate the bill being implemented, but it probably won't be passed before spring next year. And we're more likely to be probably this time next year before it comes into implementation. There will be kind of 2 periods. So there will be at least a 6 months notice period for the first implementation date. So that will be from when all new tenancies will then fall within the Act. And one of the main things is that all new tenancies will be periodic and governed by the new rules. So those new tenancies will probably be 6 months on from the first implementation date, so when royal assent is secured. And then what we'll then see is a kind of transitional provisions section, so about the existing tenancies, which will then transition from their current AST status into the new system on a second implementation date. And that's probably going to be at least 12 months from that first date. The second question we had was, is it expected that changes in this bill will be retrospective? There will probably be, well, there's almost certainly going to be a transitional savings clause. So on the commencement date, so that's the date chosen on the enactment of the bill, any tenancy created after that date will then be caught by the Act. There will then be the extended application date, which will then cover any existing ASTs. which will then, once that term comes to an end, will then be converted into a periodic tenancy by virtue of the bill. And that will happen when the current fixed term has come to an end. And then you'll have those tenancies which are currently subject to Section 21 proceedings. If a Section 21 notice was given whilst a tenancy remained as an AST, it will remain as such until it's finally disposed of through court proceedings or settlement or whatever. So that's the kind of provisions on implementation. Perhaps we can now move on to the kind of more juicy subjects, such as how will Section 21 evictions change? We had a question specifically about deposits, Victoria, which perhaps you might want to take. And the question was, do you think the new Section 2152 of the Housing Act 2004, sorry, now the new Section 19.5 of this bill, mean that protection of a deposit late will be sufficient for bringing proceedings?
Thank you, Charles. For those of you who are perhaps not familiar with the sections referred to in this question, the bill basically contains a substitution of Section 215 in the Housing Act 2004, which essentially relates to the protection of deposits in assured tenancies and how this interrelates with a claim for possession. So as to whether the late protection of the deposit will be sufficient to bring proceedings, my view is that it would be sufficient, and that's because of subsection 2 of the proposed substitution. And I would just read out the relevant part. So the court may make an order for possession of the dwelling house let on the assured tenancy only if such requirements of the scheme as felt to be complied with by the landlord on receiving the tenancy deposit have been complied with, whether or not within the period mentioned by Section 2133 in relation to the tenancy deposit. So some of you will undoubtedly be familiar that Section 2133 prescribes the 30-day period for the protection of the deposit. So the wording of this provision would imply that as long as the deposit has been properly protected as per the requirements of the deposit protection scheme, even if this wasn't done within the 30-day period, one would not be precluded from seeking an order for possession. Now, of course, if the bill is passed, and this element may be tested in case law, and there may be some interpretation as to whether there are varying degrees within this provision, but on a literal reading, I would construe it to mean that the late protection of a deposit would not preclude a landlord from bringing a claim in possession, which leads me nicely into talking generally about the abolition of Section 21 evictions. Thank you, Charles. So naturally, this element of the bill has drawn a lot of attention. And if it is passed, I imagine it will have a significant impact on landlords and tenants alike. Section 21 is essentially the procedure for seeking possession and enables a landlord to end a tenancy without having to establish a fault on the part of a tenant. And landlords often use a Section 21 process so they can use the accelerated procedure. Now, this will be entirely abolished with the new bill, and instead the grounds for possession in Section 8 of the Housing Act 1988 will be reformed to include essentially more grounds for possession. So that means a tenancy will only be terminated if the tenant terminates it themselves, or if a landlord has a valid ground for possession. Now, I won't go into those new grounds for possession now, as Rachel will be dealing with those in due course. One change in the bill, which I think might have a bearing on the abolition of Section 21, is that all assured tenancies under the bill must be periodic. So currently, tenancy agreements under the Housing Act 1988 can either be fixed term or periodic in nature. Now, this will change with the bill, and they will all become periodic, which ultimately will give tenants more flexibility to end their tenancies, whether that be because of a change in circumstances, whether landlords failing to meet their obligations, or potentially where properties are of poor quality. And this may assist to deal with some of the issues which Section 21 was originally intended to deal with. The parliamentary report on the end of no fault Section 21 evictions, which is dated 7th of March 2023, and that can be just accessed online. It discusses an exception which will essentially only apply to students living in privately run, purpose-built student accommodation, who will essentially be governed by the same rules as those in university-owned accommodation. So that means those providers who've joined government-approved codes of practice. The removal of Section 21 evictions in relation to the wider student letting sector, so i.e. non-purpose-built student accommodation, that is a more controversial point. It's still something which I think will come up as quite a hot topic in debate, so definitely something to watch. But ultimately, the abolition of Section 21 evictions may potentially lead to landlords wanting to sell their rental properties before the bill comes into effect. It might lead to landlords perhaps wanting to conduct interviews with prospective tenants and conduct more stringent references and checks on prospective tenants than perhaps has been done up until now. There's also the issue in relation to the effect of prescribed documents. Now, these were naturally previously required for Section 21 notices, and you'll be aware of, for example, with gas and safety certificates. So this essentially goes back to the substitution of Section 215 that I referred to earlier in relation to tenancy deposit. So that substitution states that an order for possession can only be made if the requirements of Section 2135 and 6A have been complied with. So that includes the provision of prescribed information in relation to tenancies, tenancy deposits, but the 30-day limit for provision of the prescribed information is not engaged. So again, late compliance appears to be possible in relation to that prescribed information in order to claim for possession. The other requirements that many of you will be aware of, such as EPC, how to rent guide, and gas safety certificates, they don't appear to have any equivalent here in the bill. So it's not yet clear what, if any, penalties or restrictions for non-compliance will be, and whether that will be brought forward, or if the requirements will simply fall away with assured short-hold tenancies. Now, gas safety certificates, there is standalone legislation in relation to that, which haven't been factored into the drafting of the bill. So this is inevitably has to be something which will crop up in debate and may lead to further amendments. But I'll now hand over to Charles to go on to the next topic on the agenda.
Thank you very much. So the next one is, what are the proposed new grounds for possession? And the question that we received was, without Section 21, will we see a fight for more grounds of eviction being inserted into Section 8?
Thank you, Charles. Well, to answer the question plainly, yes, there is going to be a huge bolstering or strengthening of the mandatory grounds existing, with some amendments made to existing grounds, but also some completely new additional grounds added. If we could just go back a slide, thank you. Don't give away all the goods before we've started, Charles. Right, so if I'm going to go through not all of them, but the key core mandatory grounds that affect the private rented sector, or we envisage impacting the private rented sector. So the first ground is an amendment to be relied on by landlords when they require the property for themselves to live in, or for a family member to live in as a principal or only home. Now, we do have guidance as to what will be classed as a family member. This will include the landlord themselves, the landlord's spouse or civil partner, or whom the landlord lives with as if they were married or in a civil partnership, parent, grandparent, sibling, child, grandchild, and or a child or grandchild of a person mentioned in B, namely the spouse or civil partner. So a fairly extensive list, and some conditions will be attached to this particular ground. So this will only be able to be invoked after 6 months of a tenancy. Despite this moving onto a periodic shift, a tenancy will need to exist for a certain amount of time. And also, if the landlord uses this ground and the tenant leaves, the landlord cannot then let or advertise said property for the next 3 months. If they do this, and they are reported to have done this, then the local authority may impose a financial penalty up to £5,000, or they may even be prosecuted criminally. So I suggest at this stage that there's probably some clear practical and enforcement issues here. Who will be reporting this? Will the tenant really be keeping tabs on landlords advertising the property? And are they really going to challenge whether this purported person is a family member? But at least we're seeing some sort of protection of trying to prevent abuse of this particular ground. Ground 1A is a completely new addition and probably going to be quite popular. This is where the landlord intends to sell the property and therefore requires vacant possession. Again, has to be within 6 months of the property. 6 months of the tenancy, unless a compulsory purchase order is involved. So that's actually protecting, I suppose, more larger scale housing projects. I will go into notice periods shortly for all grounds, but this one, it should be noted, at least 2 months notice need to be given for ground 1A to be relied upon. Ground 2 is an amendment, a small amendment. This is where a mortgagee requires possession to sell the property. The shift here is that there will no longer be, at least as it stands, there will no longer be a requirement that the mortgage had to have been entered into before the tenancy began. So a mortgage could theoretically come in 6 months into the tenancy and that be enough to give grounds for possession, again, providing a bit more protection for mortgagees. Ground 4, this ground has always existed, but it very, very rarely relied upon. We may see a little bit more reliance given the fact of student issues with student letting, which we'll also go into. But any accommodation that was previously let by an educational establishment, such as a university or some sort of schooling trust, will be allowed to be relied upon for vacant possession. And then ground 6 as well, a slight kind of amendment here with redevelopment purposes. This can now include any relevant landlord, whereas before it was only referring to superior landlords. But again, this the tenancy ought to have been existing for 6 months before date of notice of this. If we now move to the next slide, which I do suggest is the big hitter. So if you are falling asleep, time to wake up now, because this is where the big amendments are happening. Ground 6A, this is a complete new addition, and it's, I suppose, showing Parliament's intention to crack down on any kind of enforcement, non-conformance, non-compliance with enforcement actions. So, for example, where tenants breach planning matters, such as breach of a banning order under section 16 of the Housing and Planning Act 2016, perhaps a breach of a prohibition order, or probably quite popular, a breach of a HMO, illegal subletting or breaching of planning permission on that basis, that will be grounds, mandatory grounds to bring bring vacant possession. Ground 8, interestingly, there has been some discussion as to whether the government would remove this idea that you need to have the threshold passed, not only at the time of notice, but also at the time of the hearing. I'm sure a lot of people here on this call have had situations with clients where there may be repeat offenders in terms of tenants who pay just below the threshold by the time we get to court and do this on multiple occasions. But that is still existing in its current form, ground 8. The amendment here is that is to protect those on universal credit. So any amount of universal credit that was unpaid only because the tenant had not yet received it will not count towards the threshold, and therefore it may not be enough to bring a ground 8. So an interesting I suppose non-amendment to that ground, but ground 8A is the big one here. This is a real strengthening of the discretionary grounds of 10 and 11, namely failure to pay rent on time, persistently, this will be a mandatory ground. If rent arrears of more than 2 months or 8 weeks as a threshold have been unpaid on at least 3 separate days within a 3-year period, quite a long period, notice can be served in a mandatory ground 8A. Now, the practical consequences of this are quite large, and there has been some criticism. If this was to be enacted today, let's say, we're obviously looking over the 3-year period of COVID times and encapsulating COVID periods, it would mean that if tenants went above the threshold for just 1 day, paid it off the next day, but did that 3 times over 3 years, they could be evicted, which I would suggest it does strengthen the landlord's position, but is subject to quite severe criticism at the moment on behalf of tenants. Ground 14 then, this is regarding the antisocial behaviour ground. There is a small change to the terminology which may cause quite a wide impact. So previously it was stated likely, as it currently stands, likely to cause nuisance or annoyance, is looking to be amended to being capable of causing nuisance or annoyance, which of course is widening the net as to what we will deem to be a nuisance or to be an annoyance, and the threshold, I suppose, is getting lowered somewhat. So I suppose a preliminary comment on this, that this bill is being heralded as an absolute triumph for tenants, with the abolishing of section 21, which of course was known as the no-fault, or is known as the no-fault evictions. But with this bolstering of the mandatory ground, there is quite a lot of protection and quite a lot of reasons that landlords can rely upon with regards to getting evictions, and perhaps this bolstering is in fact protecting the landlord's position.
Yeah, I have a question actually, Rachel. So with this change, what is likely to be required to substantiate these new grounds? For example, will a notice of intention to sell, will that easily be challenged by tenants?
Yeah, it's a really, really good question. And unfortunately, that there is little guidance. And in fact, I've just gone on the government website guidance for this bill, and they've explicitly stated they will not be mandating any kind of evidence that is required for these grounds. This, of course, could open these grounds up to a little bit of abuse to be used by landlords. For example, the intention to sell, well, what do you need to prove that? It's unlikely that you're going to need to have full exchange or contractual documents, but the court may want to see some sort of substantive proof of an offer for sale, or perhaps it's enough just to say, well, this property is on the market, so we may just want to be advising clients to go to an estate agent, draw up some sort of particulars, and that should be enough to satisfy. An interesting point on this, the word intention reminds me of the wording in the Landlord and Tenants Act 1954, which is related to business tenancies, that where landlords oppose a business tenancy on the ground of intention to demolish or reconstruct the premises, the courts require proof not only at the time of notice, but also at the time of hearing as well, if this turned into a substantive dispute. And it may be that a similar requirement will be required if this went to trial. We just don't know at this stage. It is too early to say, but it is definitely something that the government will need to provide at least some guidance on.
Which
okay.
I think, Rachel, I think you were going to come back to notice periods, and I think we've had one question already actually about what are the notice periods. So hopefully this slide will assist.
Indeed, yeah, very handily within the Act at the moment, there is this table which sets out the notice periods for each of the grounds, which will be very helpful in terms of advising clients. I suppose the one real one to keep an eye on at the moment is ground 8, changing from 2 weeks to 4 weeks, beginning with the date of service of the notice. But of course, intention to sell, ground 1A, probably quite a hot one, will be 2 months notice in line with the current section 21 notice period. So this may change, but it is a helpful little guide for those advising clients.
Thank you very much. What about student lets? We had some questions about this. Firstly, do you expect that there will be amendments regarding student lets?
Yeah, student lets is such a hot topic, and the real issue, as that question says, will it still be possible for student lettings to be agreed 6 to 9 months in advance as at present? The real issue with student lets is the seasonality of it and the timing. You're only really wanting to rent to students for a year, sometimes 9 months, and will landlords and tenants be able to contract out? Yes, they can potentially agree that it will be a 9-month tenancy, for example, and kind of contract out of this idea of a periodic tenancy, but the statutory grounds, the mandatory grounds, will always exist and will always be able to be used, so it has not really much practical effect. This leads, well, I'll also say that Chris Norris of the National Residential Landlords Association gives a proposal that our recommendation is that the government add a possession ground that, subject to tenancy qualifying as a student tenancy, what that will mean and how we define it, who knows, could be used by landlords to bring a periodic tenancy to an end in line with a point in the academic year. So maybe providing some sort of extended differentiation for student tenancies, but I can already foresee some problems in terminology and proving that one as well. If we can just go to the next slide, please, Charles, just a very quick overview of the abolition of fixed tenancies. Victoria's done a fantastic job of going over this, but there will be no such thing as a fixed term. All tenancies will be periodic, and those will not be allowed to be any longer than a month. The period will be determined by the payment frequency, so it could be weekly, it could be fortnightly, but it's only up to a month. And the last bullet point there, existing tenancies rental payments will have to be calculated in line with this monthly period. So I've given an example of a £3,000 for 3 months. It will have to be there's a formula provided within the renters bill in order to ensure that it is a monthly rental period, which shows Parliament's commitment to this to a certain extent. There was a question as well about Section 5 and whether this continues if they are monthly periodic or changes. Well, it's difficult to answer that to a certain extent as well. I mean, the current enaction of the bill, Section 4A, is to be inserted in front of Section 5, stating that it should be moved to a periodic, and this will only be as much as a month. And so Section 5 continues to exist. So it assumes that tenancies will carry on as they are if they are already monthly periodic, but I suppose move on to at least be bound by the terms of the Act by the implementation date, I suppose is the best we can give. Just one final thing from me before I shut up and move on. There is an abolition of rent review clauses, which means landlords will not be allowed to include rent review clauses, for example, increasing once a year in line with RPI or something like that. There will be 2 regimes. Terminology is shifting. I'm not sure we've actually gone into too much detail. It will no longer be assured short hold tenancies, but just assured. That will be the private renting sector. And then low-cost tenancies, which moves more to the public secure tenancies. So with assured, landlords will have to provide 2 months notice of their intention to raise the rent, and there are 3 ways to do this: either a notice under the Housing Act 1988, that they're intending to do this, they can do that once a year, a determination under Section 14 going through the tribunal, or an agreement in writing between the landlord and the tenant that they intend to vary the rent following a determination that took place. So that's something to bear in mind also.
Great. Should we move on to pets? Everyone likes pets, or everyone dislikes pets. Everyone's got a view on pets. Aaron, perhaps this is a chance to bring you in. Will landlords be forced to allow pets? And specifically, one of the questions we received was, will landlords be able to charge tenants for pets in the property?
Thanks very much, Charles. Yes, this is surprisingly a divisive topic. You're either sort of on the side of pet owners or you're not. There's not really a middle ground. The short answer to the question is yes, they will now be able to recover or at least indemnify their position as regards to any damage caused by pets. So I'll explain in just a moment what the new provisions are, and they will be implemented as implied terms within the tenancy agreement. These changes are welcomed by pet owners who've struggled to find private rented accommodation. Anyone who owns a pet knows that if you go onto Rightmove Zoopla, whatever it is, and you look at the description of a rental property, many of them will say, sorry, no pets allowed. And that just drastically reduces the pool of properties available for tenants with pets. I suppose it's also relevant to highlight that these changes come about at a time where statistically more people have pets these days, particularly since COVID. There's been a sharp increase in pet ownership, but also we think about hotspots where there's been a lot of property development. It's often in urban areas, it's often in places where flats are being built, and often the landlords of flats are the ones who are most likely to say, sorry, no pets allowed. So it seems that eventually or inevitably the government were going to deal with this issue at some point. So there are two real implied terms that we need to be aware of on this particular issue. The first is that tenants will have the ability to write to the landlord and seek permission to keep pets at the property. And importantly, that permission cannot be unreasonably refused. I'll come back to the grey area that is unreasonable refusal in a moment, but that's the key point here, which is as long as the objection is unreasonable, that there isn't going to be scope for a landlord to refuse permission. And then the other implied term is that landlords may recover the cost of either pet insurance, or they can indemnify themselves against the risk of keeping pets in the property. So it seems like there's a bit of a balance here, a bit of give and take between pet owning tenants and their landlords. Just to delve into the indemnity and insurance issue a little bit further, we have two options really that landlords are likely to use. On the one hand, they can leave the sorting out of insurance and so on with the tenant. So it might be a condition of permission to keep a pet at the property. It might be a condition where the landlord says, well, you can keep a pet, but you're going to have to get appropriate insurance, or you're going to have to indemnify me against any damage that's caused as a result of the pet being at the property. So that's sort of option one. Option two is that the landlord could take it upon themselves to get insurance, and whatever the premiums are, whatever the excesses that need to be paid are and so on, can be recovered from the tenant. So that's option two. Of course, there are practical things that arise there. For example, if the landlord is undertaking the task of getting the appropriate insurance, they need the correct information from the tenant as to exactly what type of insurance will be appropriate. But also, it raises difficulties such as if you imagine a scenario where there's a pet at a property for months, say 6 months, but actually the landlord has undertaken an insurance policy for a year or longer, which is often the case in order to get cheaper premiums and so on. The way the bill is currently drafted would mean that the landlord is still entitled to recover the cost of the full policy if they are committed to it and they can't get out of it, even if there was no longer a pet at the property. So I think that needs to be clarified and refined a little bit, but in principle, the landlord is financially protected here. Just to come back to a couple of issues, what constitutes unreasonable refusal by the landlord? That is a huge grey area. There isn't too much help in the bill as it's currently drafted on that point. You know, if we use common sense, we can probably determine that if there is a real risk to other people that live in the property, if there's a real risk of damage and so on, these might be reasonable grounds to refuse permission. But of course, it's incredibly subjective. It depends on the pet in question. It depends on the property in question and so on. So again, my view is there needs to be a further clarification as to what unreasonable refusal might be. And then the other point is that in terms of the 6 week time period that the landlords will have to respond to tenants, so it's currently 42 days that they'll have to respond to this written request for permission, that itself can pose some challenges, because in reality, a tenant who owns a pet at the moment is going to want to make the landlord aware of the intention to, for example, move into a property at the start of the tenancy. Is 6 weeks a reasonable time period to get a response from the landlord. Obviously, they need some time to consider the request, but in reality, a landlord might use that 6-week period to go and find another tenant that doesn't have a pet, if they are really against pets being kept at the property, and sort of get around this unreasonable refusal issue that way. So potentially this leaves some space open for landlords to game that 6-week time period a little bit. But it'll be interesting to see how landlords attempt to get around this. Maybe the average landlord will simply say, look, I'm going to be indemnified, or I can have an insurance policy in place, so I'm open to having pets at the property, but we'll see.
Aaron, I have a question for you on this one. Interesting talking about pet insurance. It reminds me of the Tenant Fees Act 2019 that was brought in to protect tenants from having to pay a variety of additional fees, such as this one. Do you think this implied term regarding pet insurance will come into conflict with the Tenant Fees Act?
Yes, so on the face of it, this implied term in relation to indemnities and insurance and so on the face of it, it does come into conflict with the Tenant Fees Act. But what the bill proposes to do is actually create a carve out within section 1 of the Tenant Fees Act 2019, so that this becomes an exception to the general rule. The general rule is landlords aren't supposed to, leave the bill for additional insurance policies with tenants, but this will be a carve out to that. So section 1 of the Tenant Fees Act will be changed to accommodate this implied term.
Great.
I think I'll hand back over to Charles.
Thank you very much. There we are, pets covered. Let's deal with ADR and everyone's alternative dispute resolution. I understand that there's going to be an ombudsman. Victoria, perhaps I can bring you back in. How will the introduction of the ombudsman affect claims for housing disrepair / the landlord's liability for damages and costs for successful claims?
Well, firstly, the Ombudsman will be introduced with royal assent. So any claims issued in the courts prior to the introduction of the Ombudsman will likely still be decided by the courts, and any damages and costs ordered by the courts will still need to be complied with. The Ombudsman will essentially provide an independent and binding resolution in relation to issues including property standards and repairs, which is the big one, maintenance and landlord practice and behaviour in the sector. As the decision of the Ombudsman will be binding, as with a decision, for example, from an arbitration, the intention is not that the parties following receiving a decision from the Ombudsman would then go and litigate through the courts. So the government has essentially said that the Ombudsman will fit seamlessly within the existing system, and it will complement, not duplicate, the work of local councils and the court system. But one point that's not entirely clear to me is whether the decision-making criteria which will be applied by the Ombudsman will be at all different to the jurisprudence applied by the courts, and if they will still seek to mirror and apply the principles of common law in those areas. Disputes which will still require judgments from the first tier tribunal include rent disputes, appeals by landlords against financial penalties imposed by local councils, and applications to recover prohibited fees under the Tenant Fees Act. Charles, if you could just move on to the next slide, please. Yes, so along with the Ombudsman, the bill will introduce a new portal, essentially, which landlords will be legally required to register themselves on and their properties. This portal will be online, and it will essentially contain all the relevant guidance for landlords, and will keep landlords abreast of any regulatory changes and any changes to their requirements and responsibilities. If landlords aren't registered to the portal before they advertise their property, they could face a penalty which includes a fine of up to £30,000 or face criminal prosecution and a banning order. Now, this portal will essentially allow tenants and councils to find out their landlord's identity and the details of the property. But it's still not entirely clear as to the scope of the information which will be made publicly available. So naturally, the government will be considering some privacy issues there. The Ombudsman service will also be a legal requirement for landlords to be a member of. It appears that the government are looking at perhaps tying up the signing up of landlords to the portal with the signing up to the Ombudsman service, because essentially the information that landlords will have to provide will be relatively similar. So hopefully that streamlines the process a bit for landlords. The Ombudsman service will be free for tenants, but landlords will have to pay a fee for the essentially the operation of the Ombudsman services. It's not clear how often that fee will have to be paid, if it's a one-off, and how much that will actually be. As already mentioned, the Ombudsman would have the power to issue a binding decision, and the remedies at their disposal include the ordering of payment of compensation, which is capped at £25,000. They can order for remedial action to be taken, compel an apology, and also the provision of information. Landlords themselves won't have the ability to use the Ombudsman services to complain about a tenant. So in reality, it's envisaged that the bill will be favourable to landlords to the extent that it's likely to be more cost effective than litigating through the courts, and potentially more time efficient as well than going through the courts. The final point to bear in mind in relation to the Ombudsman service is they're also considering creating a mediation service within that service. I envisage that this is probably to cast a net over those disputes which don't neatly fit into the categories they've already named will be within the Ombudsman's remit. So that gives a broad overview of the Ombudsman and portal services. And Aaron, I believe, will now go through the practical realities of the bill for landlords and tenants.
Thanks very much, Victoria. So just to cover off on some of the issues we've touched on, and we can really look at this from the perspective of both landlords and tenants individually. We begin with landlords. Practical realities. This is a balancing act when we look at the grounds for eviction, because the taking away of Section 21 obviously gives landlords less control and less scope to evict tenants. But there is that strengthening, on the other hand, of the mandatory grounds. So there is a balancing act being had here. There is a bit of give and take. However, as Rachel has referred to, it seems that on balance, a tenant, particularly a tenant who's not in breach of their tenancy agreement, they're keeping up with payments and so on, they are going to get the better end of the deal, it seems, when it comes to the grounds for eviction. It's also interesting to observe how these changes might affect the interaction between the private rented sector and the social rented sector. It's often the case that if for whatever reason a tenant, let's say, falls into financial difficulty, many of us have seen this in practice, where the next step for them is to move from the private into the social rented sector. That's obviously a huge political issue, because A, it's expensive, and B, in many areas there are simply not enough properties to keep up with this flow of people from the private to the socially rented sector. It may be that these provisions, because they'll result in probably longer tenancies, more security of tenure, it may be that that flow of people from the private to the social rented sector is stemmed somewhat, but we'll see. As we've covered, there's less control over rent increases because there are no fixed periods, and because landlords will to some extent have to justify or be reasonable about rent increases. There is then less control for them to just increase as and when they want to. Victoria has mentioned the dispute resolution process, which is obviously in favour of tenants. It allows them to bring their issues to the fore. But in isolation, it seems as though the solution there could come about a lot quicker in terms of the solution to a dispute, because the Ombudsman can deal with it, presumably quicker than a court. But where the two processes come together, the Ombudsman process and the court process, one may potentially hold up the other. For example, if there is a Section 8 claim that's issued, but then the tenant raises an issue which could presumably be dealt with by the Ombudsman, it may result in proceedings being stayed, proceedings being delayed, and so on. So we'll wait to see how those two processes interact with one another. And then, as I've already covered, there seems to be a reasonable compromise on pets. Yes, a landlord cannot unreasonably refuse, but on the other hand, they're going to be reimbursed if there are expenses that arise as a result. For tenants specifically, I've covered briefly already, there will be increased security of tenure. There will be longer tenancies. You'll probably have scenarios whereby these days people often have to go between different properties every year or two. In the future, it's more likely that people will be able to stay in one property for longer periods of time. The Ombudsman process and the way in which tenants can complain about properties brings about some transparency, which might also inspire improved property standards. If a landlord knows that there is going to be effectively a public record of the state of the property and how they've been, or whether they've been keeping the property in good repair or not, that hopefully incentivizes them to keep higher standards. The bigger question, though, that a lot of tenants are thinking about is this going to result in higher rent? Well, it depends on a number of factors, but the principal one is being how landlords are going to react to this. We've already seen in recent years that in some areas, landlords are coming out of the market in huge numbers. And obviously, if there's less housing supply on the rental market, rental prices are going to go up. But then the other thing, of course, is that in anticipation of these changes coming into effect, if landlords think, well, my best chance of increasing the rent now will help me to, be able to deal with the rent increase now and not have to fight to get a rent increase later or have to justify it later, there may be more short-term rental increases that we see in the market. And then the last point is on referencing, and this was covered earlier as well, because landlords are faced with the prospect of having longer term tenants, they may be more focused on ensuring that they have the right tenants for their property, and so the referencing process may be more stringent.
One question for you, Aaron. Obviously, you've raised a lot of points for both landlords and tenants there. What do you think are the, say, key predictions for both landlords and tenants, and what they need to bear in mind if this legislation is passed in its current form?
If I could distill it down to a couple of key takeaways, I'd probably say, number one, for a tenant that is paying on time and they're keeping in line with the tenancy agreement, they are going to have a hard time, but landlords are going to have a hard time evicting a tenant who is behaving, let's say. So that's one takeaway, which is obviously good for tenants. The second will be, as I say, on average, tenancies will be longer. There will be no fixed periods, and so people will find it much easier to find a property they like, stay in it for long periods of time. And maybe that's a good thing for both parties. If there is that, from the tenant's perspective, if they have a good landlord, and from the landlord's perspective, if they have a good tenant, if both parties are happy, then longer tenancies are probably a good thing. And then finally, I'd probably say that we'll wait to see how this actually impacts the market. But the fact that Section 21 notices and that whole process is being removed might lead to a last minute flurry of Section 21 notices leading up to when this bill is implemented. For landlords who are on top of these changes, expect them to come out, we might see that they invoke that option before they lose the right to do so.
Well, thanks very much, one and all. I think we've kind of covered off the highlights, or what we see as the highlights of the Act, or the bill, I should say. There are some other provisions in the bill which we ought to kind of flag to you. such as the kind of requirement for heads of terms, decent home standards, and kind of more data collection and compliance with landlords or hoops for landlords to jump through. They're kind of quite discrete issues, so read the bill or read the act when it does come out. As we mentioned at the outset, this is a bill that's currently in its infancy. It's going through Parliament now. Nothing is certain. So if you or your clients have any concerns, write to your MP, say this is actually going to be unworkable because of X, Y, and Z. There's nothing to stop you from doing that. And hopefully you've got a MP who hasn't recently resigned and triggered a by-election, and they will respond, hopefully, and raise the question when the bill's next in Parliament. All that leaves me to say is thank you very much for taking time out of your busy schedules to listen to us talk about the bill. It is an interesting bill, and we will be sending over a copy of these slides to you all so that you've got them, so you're aware of the kind of key issues that we've flagged during this webinar. I would also like to thank Rachel, Victoria and Aaron for doing all of the hard work of reading into the bill and preparing the slides, etc. It's been a pleasure for us all to speak with you this morning. We will leave you in peace to go and enjoy the sunshine as and when you can. Yeah, thank you very much for attending, and we look forward to seeing you at the next 3PB event. Many thanks. Bye-bye.
Thank you.
Thanks
for joining us.
Bye.